Thank you, Mr. Chairman, and thank you for your fair administration of this hearing. I'm honored to represent the city of Chicago, and we've got some basic stories that are taught to all newcomers on the political scene. And one of them involves a former former judge whom many of us knew personally, Abner Mikva. Abner Mikva was a law student at the University of Chicago, and he decided in 1948 he wanted to volunteer to work on local campaigns for Paul Douglas for the United States Senate and Adlai Stevenson for governor. So he went to the 5th Ward headquarters. Ward headquarters are a big deal. They were in the city of Chicago. And the ward committeeman, Timothy O'Sullivan, was there. And this new law student, Mikva, walked in and said, "I'd like to volunteer to be part of the Douglas and Stevenson campaign." Timothy O'Sullivan took the stump of a cigar out of his mouth and said, "Who sent you?" Mikva said, "Nobody sent me." Sullivan said, "We don't want nobody sent." Mikva told that story because it really kind of gets to the heart of politics in that city and a lot of other places, and it's a fair question, isn't it? Isn't it a fair question about Neil Gorsuch? Who sent him? Why are we considering this man for a lifelong appointment to the highest court in the land? And the answer is obvious. We know who sent him. I have to agree with Senator Graham. I don't know what Donald Trump's I know his political philosophy a little bit. I don't know his judicial philosophy as president. But we sure do know the judicial philosophy of the Federalist Society, which was given the responsibility of coming up with the list of nominees to fill the Scalia vacancy on the Supreme Court. They did it. Candidate Donald Trump announced that list, which has been referred to, of 21 names. In fact, the Federalist Society takes pride in the fact that they say that under Republican presidents, every appointment to the Supreme Court has either been a member of the Federalist Society or cleared by the Federalist Society. Think about that for a second. I don't remember seeing the Federalist Society in the Constitution, but they've come to play a constitutional role when there's a Republican president. They pick the Supreme Court nominees. If you ask them, well, what do you use as a criteria? I'll go back to another Chicago story from a fellow I worked for. His name was Cecil Partee. He used to say in politics, for every issue, there's a good reason and a real reason. What's the good reason the Federalist Society tells us for their selection of nominees? Well, it goes back to a speech in 1985 by Edwin Meese to the Federalist Society, where he tried to come up with some basic definitions of what they were all about. He said they were rooted in the text of the Constitution as illuminated by those who drafted, proposed, and ratified it. He called this Federalist Society standard a jurisprudence of original intention, contrasted it with the misuse of history by jurists who saw in the Constitution's spirit things like, quote, concepts of human dignity, close quote, with which they turned the Constitution into a, quote, charter for judicial activism. Have we heard these phrases, originalism, judicial activism, over and over and over, and we are told, rest easy. Neil Gorsuch is an originalist. But if you're going to get into a real analysis of what constitutional originalism is all about, be sure to read the words of Justice William Brennan, who said that anyone who had ever studied in the archives knew better than to believe that the records of the Constitutional Convention and the ratifying conventions offered so certain, exact, and singular a verdict as that which Meese expected to find there. Brennan called the idea that modern judges could discern the framers' original intention, quote, little more than arrogance cloaked as humility, close quote. So excuse me if I'm skeptical about the good reason why the Federalist Society gets to pick Supreme Court nominees for Republican presidents. Perhaps, let me suggest, a real reason. Who belongs to the Federalist Society? Who funds the Federalist Society? To a point made over and over by Senator Whitehouse, they allow their donors to remain anonymous, but some do publicly disclose that they contribute. Who would they be? Try the Koch brothers, try the Richard Mellon Scaife Family Foundation, try the Mercer family, which I'm reading more and more about. Billionaires who believe they want to control this political process. Do they have an agenda? Of course they do. We know it. We see it all the time. And that is what this decision process has become. And so here comes Neil Gorsuch from the 10th Circuit, who comes before us presenting his credentials, and we get a chance to ask questions. We know he's received the stamp of approval of the Federalist Society and the Heritage Foundation. And we ask some basic questions to try to understand, is he really a captive of this special interest group? Or is he something else? And the questions we asked, I laid out my expectations in a February speech on the Senate floor, what I needed to hear in there. I asked, can you demonstrate that as a Supreme Court justice you would uphold and defend the Constitution for the benefit of everyone, not just the corporations, the privileged elite? Can you demonstrate that you will be an independent check on this president or any president? Can you show you're prepared to disappoint this president who chose you and the right-wing groups that have taken credit for your name coming before this committee? And I said, you need to be forthright about what your values are. Well, today's opening day of the baseball season a few blocks away from here, and unfortunately for those 4 questions, Judge Gorsuch went 0 for 4. He told us he wants to be judged based on his own record, not the views of Donald Trump or anyone else. Well, let's look at his record. 10 years on this circuit bench. In case after case, he favored corporations, employers, and special interest elites, the very folks who sent his nomination to this committee. He favored them over workers, consumers, people with disabilities, and victims of discrimination. He says he neutrally follows the text of the law and the original intent of the law, and yet we can find clear patterns where he bends precedent and selectively focuses on some parts of text and not on others. Alphonse Madden has become legendary in this committee. This poor frozen trucker out on Interstate 88 west of Chicago in January, 14 below, given a choice between freezing to death and sitting there and waiting for, as he sat and waited for a repairman, or dragging a disabled trailer out on the interstate and endangering his life and the life of others. My friend and colleague, Senator Franken, said it was an absurdity, and as he reminded us, he specialized in absurdity in a previous life. Well, in this situation, 7 judges took a look at Alphonse Madden's plight, and 6 of them said it was clear. This man did what any reasonable person should do, and he shouldn't have been fired for it. The one judge who didn't see it that way, Neil Gorsuch. The Luke P. case came out, if you recall, in the midst of our hearing in this room. The Supreme Court unanimously, an opinion written by Justice Roberts, unanimously struck down the very words written by Neil Gorsuch when it came to this poor disabled child and his education. And I have to disagree with my friend from South Carolina. He was not just applying precedent. Read the exchange between Neil Gorsuch and Senator Klobuchar. He was doing more. He was reaching into another circuit, and he was embellishing that standard with a word which clearly, as the Supreme Court found, meant that kids like Luke P. would get no education at all. Grace Wang, we didn't talk about her too much at this hearing. We should have. Professor at Kansas State University, diagnosed with cancer, facing a bone marrow transplant. She was given 6 months off for this amazing, important, and dangerous operation. She's supposed to return to the classroom at the end of 6 months, but there was an influenza epidemic on campus, and she said to the people at the university, "I'm afraid to go back. I'm very vulnerable, having just gone through a bone marrow transplant." And they said, if you don't return to the classroom, you're fired. It was Judge Gorsuch who wrote the opinion that said that was a reasonable decision by Kansas State. I don't think it was, but I think it's a reflection on his values. NLRB versus Community Health Services, his dissent contorted NLRB precedent and authority and argued that workers who were unfairly locked out would get a windfall if they received full back pay, while also keeping their wages from second jobs. I won't go through all the list of cases. We've read them all. And they do paint a very troubling picture of Judge Gorsuch and his values. There's a clear pattern in these cases. Judge Gorsuch claims to support supposedly neutral philosophies, but somehow, time and again, they lead him to the same outcome. The worker, the victim, and the consumer lose. The corporate elite win. He's also repeatedly shown that he does not want to follow simply the law. He wants to change the law in some cases. Federal Judge John Kane came here, testified under oath, in support of him, but he made a revealing comment at the hearing. He said, and I quote, "Judge Gorsuch is the only judge I know, only judge of whom I am aware," he said, "who has written both majority opinions and concurring opinions in the same case." Why would a judge do that? Consider one of the cases, Gutierrez versus Brizuela, where Judge Gorsuch wrote the majority opinion, then used a concurrence to call for abandoning the Chevron doctrine, which we spent a lot of time talking about. That's an idea that fits well with some people who want to deconstruct the modern administrative state. For reference, read Breitbart. But it would append agencies' liability to enforce important civil rights, consumer protection, and environmental laws. Gorsuch told us time and again, Judge did, about his efforts to ensure indigent defendants were appropriately represented. Look at his record. When it comes to Sixth Amendment, it's a perfect record. Judge Gorsuch's record, it's perfect. 52 opinions, Judge Gorsuch never, underline never, found that an attorney provided ineffective assistance of counsel. Williams versus Jones, his dissent would have found no prejudice for a defendant when his attorney said he would quit if the defendant didn't accept a plea deal, and then falsely told his client it would be perjury to accept a 10-year plea agreement instead of life without parole. I asked him about that case, and he still thought that that man had good representation and a fair trial, as he said it. Two Republican appointees disagreed, and Judge Gorsuch's reasoning was later rejected by the Supreme Court in Lafler versus Cooper, when the court held that the accused must have competent guidance from an attorney in deciding whether to take a plea deal. Judge Gorsuch has provided no reassurance he'd be an independent check on this president or any president. We learned a lot about his emails at the Justice Department. I won't replow that ground, which was handled so well by Senators Feinstein and Leahy. For my Republican colleagues who never tire of bringing up Judge Gorsuch's 2006 confirmation, may I remind you of the obvious? At that time, we didn't know about Judge Gorsuch's troubling record at the Justice Department, and we certainly didn't have a decade of judicial decisions where Judge Gorsuch tilted the playing field toward big business and away from American families. The art of evasion is certainly one that is used by most nominees who come before us, but I think that Judge Gorsuch developed it to a new level. He said virtually nothing at this hearing to ease concerns many of us had about Chief of Staff Reince Priebus's declaration that Judge Gorsuch was, quote, a man with the vision of Donald Trump, whatever that means. Of course, no one has illusions about what's going on here. We know who sent him. And we know when people talk about the American Bar Association rating him unanimously well qualified, the first name that comes to my mind is Merrick Garland. If that were the standard, we wouldn't be meeting in this formal session. We'd be celebrating the first anniversary of Merrick Garland's year on the bench. But we're not. We're here because of a Republican strategy, Senator McConnell's strategy, and the rest of the Republicans to line this vacancy up for the next Republican president. There's been a lot said about the damage that may be done to the Senate with this nomination and the votes that will be taken this week. It breaks my heart to find us in this position. I love this place. I've been here for a big part of my life. And I can remember things about it as senators who are as senior as I am, and maybe more, can remember about this institution, what it used to be like, what the standards used to be, the pride we took in the Senate. But then came this onslaught of filibusters, unprecedented in the history of this body. Senator McConnell and the Republican majority at the time, even in the minority status, did everything they could to stop the orderly consideration of bills and nominations, leading to the point where the second most important federal bench in the land, D.C. Circuit Court of Appeals, was basically frozen. They couldn't fill vacancies because of the threats of filibusters for these nominations. And that's what led to this well-worn and well-discussed rules change. And that's what brings us to this point. One of my senator friends, Senator Graham, said, Senator traditions will change this week. In honesty, they started changing a long time ago. I just hope at the end of the day we can resurrect what this institution was all about and should still be all about. This nomination does not give us that chance, unfortunately. And we know what the fate of this nomination is likely to be. Mr. Chairman, I have comments on the other two nominees, but I thought at the outset you were going to ask us to withhold those statements on Rosenstein and Bland.
I'm going to. You don't have to, but I'm going to.
Well, at the risk of going on, and I won't go on, I'll put the statement in the record. At Rosenstein's hearing, I was impressed by the fact that this man survived Republican and Democratic presidents and was U.S. Attorney. He certainly comes with high recommendations from our senators from the state of Maryland. I was troubled when he said he hadn't read the intelligence community assessment on Russia's interference in our election. He responded to my March 13th letter on the subject, confirmed he's now read the report, and he, quote, had no reason to doubt the intelligence community's assessment. I thank him for that. He also clarified the recusal of Attorney General Sessions, and I thank him for that. He would still bear responsibility for this Russian the Justice Department investigation into Russia's cyber war against the United States. I hope he'll appoint a special counsel for that purpose. He also will have responsibility over criminal justice efforts at the Department of Justice, and I'm concerned about the sentencing guidelines which Attorney General Sessions has now suggested. I'm going to vote to report him out of committee, withhold my final vote on the floor until there is some clarification about a development this week. Stephen Cook, the former president of the National Association of Assistant U.S. Attorneys, has been tapped as a Deputy Attorney General and top deputy on criminal justice policy. The media report says, quote, meet the hardliner Jeff Sessions picked to carry out his violent crime crackdown. Steve Cook, a former federal prosecutor, fiercely supports controversial policies calling for lengthy prison sentences, end of quote. Members of this committee will remember Mr. Cook from his 2015 testimony, stridently opposing the bill which the chairman of this committee and I support, the Sentencing Reform and Corrections Act. On Ms. Brand, let me say again as briefly as I can, I believe that I have to oppose her for three reasons. She spent much of this decade working as chief counsel for the U.S. Chamber. When I asked her if she would recuse herself from matters involving the Chamber, she would not make that commitment. We need that assurance before I can vote for her. Second, I'm concerned about her refusal to answer key questions about civil rights, and I'll put those in the record for reference. Third, Ms. Brand refused to say whether man-made climate change is real, whether there's a public interest in addressing it. Troubling for a person who would oversee the Justice Department's Environment and Natural Resources Division. I will assure Ms. Brand that she'll be treated better than President Obama's nominee for Associate Attorney General Stuart Dellery, who was never given a floor vote by the Senate Republicans. Ms. Brand will get her vote, but I will vote no. I yield the floor.